Can the prosecution seek to amend the subsection charging a defendant in an indictment? To find out, you have to read People versus Hemingway, but it's 3 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Hemingway. The citation for this case is 2025 New York Slip Opinion 02965, published by the New York Court of Appeals on May 15th of 2025. The issue in this case is whether amendment of a subsection of a crime, VTL 1192, drunk driving, can be modified and amended under CPL 200.70, which authorizes amendments under certain circumstances. To understand and appreciate the context of this case, what's helpful to know is that VTL, Vehicle and Traffic Law 1192, is a huge statute. It's the statute in New York that talks about drunk driving. And it's got a variety of subsections, VTL 1192 sub 1, VTL 1192 sub 2, sub 2A, sub 4, and they do different things. They address different kinds of intoxication and impairments. Specifically, 1192-2 is intoxication by alcohol. It sort of presumes that above a certain limit, 0.08, it's presumed that a person is intoxicated. And then 1192 sub 4 is intoxicated by drugs. So if you are impaired in your ability to drive because of drug use, then it's 1192-4. If it's alcohol and it's above 0.08, it's 1192-2. And the other thing you have to know is that under criminal procedure law, CPL 200.70, that authorizes the prosecution to seek to amend an indictment, which is the charging document for felonies and misdemeanors, certain misdemeanors. It authorizes amendment of an indictment under certain circumstances. And those circumstances are, it can be amended with respect to defects, errors, or variances from the proof relating to matters of form, time, place, names of persons, and the like, when such amendment does not change the theory or theories of the prosecution as reflected in the evidence before the grand jury, which filed such indictment, or otherwise tend to prejudice the defendant on the merits. So it can be amended on those different grounds so long as it corresponds to the evidence before the grand jury, which issued the indictment, and does not cause prejudice to the defendant. So what are the facts in this case? The facts are that in this case, Miss Hemingway allegedly was driving while under the influence of drugs with a baby in the car, which is a felony. And she admitted to using marijuana, and a blood test confirmed that she had marijuana and oxycodone in her blood. She was indicted by the grand jury after evidence was presented to them with respect to her drug use and her driving while impaired by drugs with a child in the car. And she was then, she went all the way through trial. And at the close of the evidence at trial, the prosecution realized that the indictment had the charge 1192 sub 2 instead of 1192 sub 4. And sub 2, if you remember, is about alcohol. Sub 4 is about drug use. So the people said, the prosecutor said, Judge, we move to amend the indictment to correspond to the evidence presented to the grand jury, which is about drug use. We presented evidence to the grand jury about drug use. They indicted. We presented evidence at trial about drug use. Our theory was always the defendant was driving while under the influence of drugs. And the indictment is incorrect. It's a typographical error, the fact that it says 1192 sub 2 instead of sub 4. And the defendant opposed this and said this is not fair. This is not the kind of thing that should be allowed. The judge allowed the amendment. The defendant was convicted. And ultimately, she appealed. The appellate division affirmed the conviction, affirmed what the judge had done, and it goes to the Court of Appeals. And here, the question before the Court of Appeals is this kind of an amendment of a subsection of a criminal statute, is that allowed under CPL 200.70? And they hold that it is allowed. They say, we agree the circumstances of this case demonstrate that the reference to sub 2 was a typographical error, and the county court did not commit error by ordering the indictment amended to reflect that it's 1192-4 instead of 1192-2. They say this aligns with the evidence put before the grand jury and does not otherwise prejudice the defendant. So it is allowed by CPL 200.70, which permits amendments relating to form, time, place, names of persons, and the like. Okay. And with respect to that, basically the holding in this case is that a subsection of a crime, of a criminal statute, can be amended under 200.70, it is not prohibited by that statute. And that's the case of People versus Hemingway. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.